Hi, everybody. Get started in a few minutes.
Starting to feel like spring up here in the Northeast finally.
Oh, that's nice.
Yeah. Seeing things bloom and
20 days here. Whoa. April. Your stuff starts blooming at the end of January, but I guess that's still snow in Massachusetts.
yeah. Our it looks like the picture basically in January without the mountains. Lots of snow.
Crazy. Good. Great to see everybody coming in. Get started. We hope everybody has lots of questions today. We'll answer them. Okay, let's hear it, Rebecca.
Good afternoon, everyone. Thank you for joining us today. I have a few housekeeping items before we get started. This webinar is being recorded and the recording link will be made available to you later. This presentation is an educational service by Alcorn Immigration Law. The information discussed should not be construed as legal advice for any specific action and is an overview only. Please be sure to consult a knowledgeable professional for assistance with your particular issue. Lastly, please submit any questions you may have using Zoom's Q&A function and do so anonymously. These questions are shared publicly, so please do not share any sensitive or personal information. It's now my pleasure to introduce you to our founder and CEO, Sophie Alcorn, and our Chief Legal Officer of Excellence, Linda Haggerty.
Thank you so much, Rebecca. Hi, Linda.
Hi, Sophie.
Welcome, everybody. Great to see you all here today. Welcome. My name is Sophie Alcorn. I'm the founder of Alcorn Immigration Law and host of the Sophie Alcorn podcast, where we talk to founders about their origin stories and IP and corporate attorneys about what startups need to know about legal, and also been exploring outer space technology in recent and space law in recent podcast episodes. So that's been fun. Great to have you here today. And what Linda and I really want to focus on is how people can self-petition their green cards and also get O-1s. And this ties into my mission, which is helping the world be a place where every child has the opportunity to go to the places where they can self-actualize and follow and build their dreams. So great to be here. And I'm here with my esteemed colleague, Linda Haggerty. She's an expert business immigration attorney with over 2 decades of experience in corporate and business and now startup boutique immigration law. Also a mom, also very passionate. Thank you for being here with me today, Linda.
Happy to be here.
Thank you so much. Okay, and for those of you who are new to Alcorn, please also meet our wonderful team. We're a remote law firm. I am based in the San Francisco Bay Area, and we have colleagues in Massachusetts, Texas, North Carolina, seasoned immigration professionals who are very passionate about helping our clients. And God, combined probably more than 100 years of immigration experience if you add it all up. So let's just kick it right off. Oh yeah, and we are going to be sharing the recording link to everybody. So If you are here now and you would like to put your questions in the chat window throughout our time together, you're welcome to add your questions in the Q&A panel at any time, and we'll either answer them throughout or we'll save time at the end, depending on how many there are. But you're welcome to ask your questions and we're happy to help you. Okay, so why this webinar? Well, there's a lot of reasons that people might want to know about getting an O-1A, potentially self-petitioning it through an agent, and having some sort of green card pathway through getting a sooner priority date, perhaps with EB2 and IW, to getting the fastest type of green card with EB1A. And it's for so many reasons. People want to do it because they're family, because they want to travel, because they want to work, and because they want to invent and create and have the freedom to experiment with being an entrepreneur or a startup founder. Linda, what are some of the things you've been seeing lately in your conversations with potential new clients about some of their motivations for pursuing these pathways?
Yeah, I mean, I would say that, a lot of them are just trying to get their company off the ground. They're entrepreneurs and they're looking at work visa pathways. And maybe the green card motivation is also so their spouse can work because their spouse is in a derivative visa and they don't have work authorization. So
That's
when we do our
true.
yeah, it's
That
interesting.
H4 EAD spouse, even if they can work, it's like, ooh, we don't want everything just to be connected to my job, because what if I get laid off, then my spouse also can't work.
Mhm. Yeah.
Yeah.
So really it's good to kind of scope out what the timeline is for the individual and what their long-term and short-term goals are. And then we can help kind of find the right fit in terms of immigration.
Yeah, because we use the same tools often for our clients, but we piece them together in different ways. And so what will help us recommend one pathway or another? Well, look, if your kid is 18 and wanting to enroll in, or 15 and wanting to apply to a state college with in-state tuition and a green card in a couple of years, that's kind of a different situation than if your spouse needs to work for the first time versus if you want to be an entrepreneur, never want to be an entrepreneur. Well, maybe you're not married at all, right? And you can just have a lot of freedom. So it kind of depends, but we see a lot of these factors coming up again and again. Also lately, I've been seeing more and more people. Yesterday, NASA announced like $11 billion funding for startups to help figure out how to get to Mars and what to do there. So like that money's going to go to US companies, with US persons at the helm. And so getting a green card would help build those control technologies, for example. So lots and lots of different reasons. So today, this webinar is to help you take charge and help you think about a plan for your personal immigration pathway. And we're going to be chatting a little bit about, H-1Bs and OPT if you're at that stage, and how to leverage these tools from that vantage point, if the O-1 is right for you and when you would go to that. And then we'll also be talking about how to get a green card and how to self-petition, and then also how the visa bulletin works, and how to speed up your or how to decrease your time to waiting for a green card. And we have some additional comments on agent-based O-1s as well, and we're going to have a separate webinar on that coming up in a few weeks. Okay, Linda, can you walk us through the visa basics of what these concepts are and what phase they come at?
Sure. Yeah, I mean, I would say the first column, visa, that's really some kind of temporary authorized stay in the US. So, when we look at visas, we're often looking at work visas like the H-1B or the O-1. People may come in as a business visitor and they come in on a visa as well, or ESTA, which is like a visa waiver. It's a companion of the B, but you don't need to get a visa stamp. And then when we look at the middle column, that's more long-term. So that's someone who wants to work in the US long-term. They can work for any employer. Family members can also work, spouse, and that's a permanent status, but it does have to be maintained. So you do have to have residency in the US in most situations. And then the last is citizenship. So that's really long-term. You can travel freely. You can spend as much time in the US as you like. And then you've got tax obligations, and then you have an opportunity to sponsor family members as well.
Yeah.
For green cards.
Wonderful. And citizenship is not a requirement. It's a benefit. It's an option. So you can have a green card your whole life and never become a citizen, or you could have a visa for decades and never get a green card. So there's different ways to piece this together. And it just kind of depends on those other goals we talked about. Some people are very clear, like, oh my God, I wish I could have a green card tomorrow because that puts me on a path to citizenship and I can sponsor my parents for green cards. And other people are like, well, you know, we're new and we're just going to test it out for a few years and see if we like it. So people are a lot of different places.
Mm-hmm.
So here's a really important concept, and this relates to people on H-1B visas and STEM OPT and F1 international students without work authorization, people with an O-1 only for a single company, and people who wish they could be dabbling in side projects that make money, whether that's consulting work, the gig economy, paid TikTok. There's so many types of things people do. Coming up with new software, raising funding. It's like, how far can I get without violating my current immigration status? And so this is a really important concept to talk about here, because the activities you want to engage in can affect your timeline for getting it, for if and when you should get an O-1 visa, and how soon you should try to get a green card. Because once you have a green card, you can pretty much do anything. Although if you get a green card through an EB-2 NIW, you are making a commitment to work on your proposed endeavor that will help America in the future once you do have your green card. But on the way to the green card, through the adjustment of status process, you can get a work permit, and with that work permit, you can do anything you want. But before that point, most typical immigration statuses are very, very limited in what you can do and if you can work at all. And so you have to be very, very careful. So, okay. So here are some things that people do pretty consistently without work authorization. Linda, can you walk us through what these are?
Sure. So when we look at internships, oftentimes that's a student that's, in a program, maybe a graduate program, and they're doing an internship associated with the school. And sometimes there is a work authorization tied to that. So they could get CPT. The other thing is, business visitors, where we see founder initiatives, right? You're coming to the US, you're looking to meet with investors, you're trying to negotiate contracts, you're just scoping out potential prospects in the US, maybe registering your company. And then the last bucket is just pure volunteering. And you've got to be careful. I hear a lot of people ask me, well, I wasn't paid, I was a volunteer. Well, you were developing software. So that's not really a job that someone would normally approach unpaid. So that wouldn't really qualify. So you've got to be very cautious about what you do as a volunteer.
Exactly, exactly. And I think a lot of this goes to the immigration definition of work, which is performing labor or services in the hope of future payment. So you don't even have to get paid yet. But if somebody's like, oh, do this free project, and when I hire you, I'll give you a sign-on bonus, that would be paid work. If it's like, oh, I know that I'm developing software to increase the valuation of my company because I'm trying to raise money at a certain certain multiple or something. It's like if you're tinkering, if you just have a garage workshop and you're pouring chemicals together and like, oops, eureka, I magically found gold. I wasn't planning on it. That's not work. But if you're like, oh, somebody's going to give me $10 million if I like mix the chemicals in the right way, then it's work. So it's like your intent at the time about whether somebody else might pay you or whether you might pay you. So it's super convoluted, but yeah, a lot of people do this stuff. It's generally okay. The company might have an issue with giving you an unpaid internship because they could have employment law liability for violating intern rules if they're putting you to work instead of educating you. So that's a Department of Labor federal thing, which is employment law. But a lot of aspiring founders do negotiate personal contracts on their own behalf, set up a company, create a bank account, talk to investors. So those are typically, I would put in the bucket of business owner activities, and they're generally allowed on a B1 visitor visa for business or ESTA, where you don't even have any work authorization at all, but you can do those things. So you just want to keep it in mind. But I would say once your company's incorporated, if you're coding, that's probably a bad idea. So it's best to code and invent and negotiate, and then talk to your immigration lawyers. And then you're probably going to be a rapid succession of making an immigration plan, putting your current day job, transferring your visa to your startup, getting funding, and then continuing to code after everything has been completed.
Mm-hmm.
Yes. So, okay. So certain stuff is definitely not allowed unless you specifically have a work visa that allows you to do it, or you have an EAD work permit that's unrestricted that allows you to do it. So what are these things referring to, Linda?
I mean, the first is really just, performing, basically executing work under a contract. So you have an agreement for services and you're actually doing the work. So you've got to be careful and make sure you're not engaged in any actual productive activities. Freelance work, I mean, I think of, Uber drivers, Lyft drivers, and, coding. Obviously, as Sophie mentioned in the last slide, that's really a no-no. That's still
And this
productive.
is like, hey, let me pay you $500 an hour to do XYZ, or, oh, give me this project and I'll pay you $2,000. I think there's people in the US who do this through their foreign company that they own and their foreign bank account from back home. I think that's still risky. And I think a foreign company could also get in trouble in the US for having you be in like a contractor here.
Yeah, and it comes up like when we go and do an adjustment of status, the green card stage, have you, basically violated the terms of your status. So working without authorization is a violation. So you do have to be extra cautious.
Yeah.
I mean, and also people don't realize where you physically located makes a difference. So if you go back home to India for 2 months and you're coding while you're in India, that's fine. But once you come into the US, you're on US soil. So you need to start productive
That
work.
is such a critical point. That's actually a huge misnomer. People are like, oh my God, I have a visa. Does it still control me when I go back home and visit my family? I don't want to violate US immigration law when I'm back home in India.
Right.
No. There's this concept in law called jurisdiction, and US immigration jurisdiction only controls people on US soil. So those are just the commitments you make when you're physically in the United States. If you're outside of the United States, it doesn't control you, unless you're like wanting to be cautious about counting your days of like OPT unemployment or something for when you return, then it could have an effect. But usually, if you need to go make money, save it for vacation, which
Doesn't sound like vacation.
sounds like vacation. Okay, and so this is a good segue into this concept, and we're going to have another webinar in a few weeks, and we're going to go more into depth on this because I think it's a very interesting topic right now as more individuals are looking at getting an O-1A visa with an agent. And so, okay, so what is this concept? So basically, on a typical work visa, like an H-1B or a normal O-1A, there is an employer that serves as the petitioner to complete the immigration forms. And the petitioner is telling the government, I petition that there's this job that needs an immigrant to come fill the role. So I would like so-and-so to do the job so they can apply for their visa and come in. So O-1 visas are used across a wide variety of industries, but they have historically been used in Hollywood for film stars and singers and other people in the entertainment industry. And so in that industry, the employment is irregular. It is rare that people would have a 40-hour a week full-time job as an employee. exempt, salaried, on payroll, getting their W-2, and they're getting their total salary by the end of the year. It is more likely in that industry that people would have random gigs, random contracts. Maybe they're being paid in their home country because they're only here for a few weeks. Maybe they're being paid here. Maybe they start multiple companies, one for their revenue for their record deals, another one where they make money for their advertising and influencer work. Maybe they have like a family foundation that they start when they're mega wealthy. And they're represented by an agent who gets them paid gigs, like, oh, film this movie. Oh, go act in this commercial. Oh, I got you a paid speech. So now you're going to go speak from the stage at this conference as like a motivational speaker. And it's erratic. They might have periods of like multiple weeks of unemployment where they're just like sitting at the Santa Monica Beach or Malibu, watching the sunset. So they're allowed to get agents. And so this legal structure was built for that, but we've been able to successfully copy and paste it from the Hollywood context to the Silicon Valley context, because legally it's the same thing. O-1s can be filed by agents. So in the immigration context, an agent is an individual or a company working in the field who is willing to serve as the petitioner for the immigrant, who is willing to take responsibility for signing as the petitioner and verifying that all of the information in the form is true and accurate, and who is taking responsibility for the person's itinerary of services, that there will be work for them in the United States, and who's on the hook for buying you an airplane ticket to go back to your home country if you get fired or there's no more work for you to do. So those are the duties that this person must serve. So the reason we like to talk about this in this context is because if somebody who's interested in tech is in the United States or wants to come to the United States, and maybe you're here as a student on regular OPT and you're like, oh, I think I want to avoid STEM OPT because it's annoying with E-Verify and the minimum hours and the training plan, or, I'm on H-1B, but I wish I could freelance and start multiple projects and test out different software concepts with different payment models and see which one strikes, so that I can turn it into a startup. And I can't wait maybe potentially years to get my work permit through the green card process. I need to do it now. Getting an O-1 through an agent is a very valuable stepping stone because we can build your itinerary so that you can have multiple engagements. So you can have your day job at a company, you can be the founder of a startup, you can get advisory shares advising your friends' startups, you can be paid to be a speaker, you could get contract work consulting and doing software development as a freelancer. You could publish a book and get paid for it in the United States. So it's a really wonderful way to basically we can structure it in a way so you basically have unlimited work authorization in your field of extraordinary ability. And that allows you freedom to create and freedom to fail on projects so much sooner than if you were just waiting for your green card. And if you can get an O-1A, it is an amazing stepping stone from which to get an EB-1A, green card eventually, because both involve extraordinary ability. It's not required that you have an O-1A first, but the EB-1A is the fastest type of green card. And I do believe that there's some sort of, persuasive reasoning and logic that happens in adjudicators' minds when they're like, oh, should this person get an EB-1A? It's kind of easy to be like, oh, well, they've already had like 2 O-1s in the past, so they've clearly been deemed extraordinary multiple times. So that's not the legal logic of how these cases should be decided, but I think it has persuasive value and gives officers comfort when they want to make an approval that somebody else has already said this person's extraordinary in the past. A reason you might not want to do this is if your spouse is dependent on an H4 for an EAD, then switching to O1 might actually not be a good solution for your family in the short term. But I've even had some people be like, okay, well, I'm going to stay on H1B, but I want an O1 approval. So can we apply for an O1 for consular processing? And I'll never activate it, but then we can say that I've had an O1 approved in the past on my EB1A. Like, that's a lot of work, but if you really want to do that, we are happy to help you. So different strategies. So that's the O1 with an agent. Linda, do you have any questions for me on that? Is there anything else that would be helpful for me to cover for this topic?
I mean, I think we can introduce an agent. So we have a company that we've partnered with before. So, you know, an agent can really be any US individual.
That's a good point.
Yeah, so there are.
We used to do it with people's friends, like, oh, well, I'm a data machine learning engineer, and so is my buddy who has a green card already, and he's willing to stick his neck out for me, or his startup can be my agent. So you're welcome to do that, and you don't have to exchange any money with the agent for immigration purposes. They don't have to get a cut of your revenue. The agent that our clients seem to like charges $1,000 per O1 petition. And the reason we started using a professional agent was because the amount of stress that it caused our clients to rely on their friends was way more emotionally expensive than the $1,000 that the professional agent charges. Because if it's like, oh my God, I got my O1, but now my friend is confiding in me that their startup is shaky and I don't know if my visa is going to go down if they close their startup. And every time my friend calls me at 2 a.m., I have to answer because they're my agent. And now it's making our relationship really awkward. There's just a lot of interpersonal dynamics that can happen. So it gives people more peace of mind to do it with a professional, I think. And we've had people with agents do consular processing now at various consulates, so it can work for a variety of situations. I think that's it. Oh,
Yeah.
one thing that I've seen in like the Reddit Discord chatterverse on immigration is that some big companies are declining to allow their employees to continue employment on an O1 with an agent. And that's really frustrating, I think. We're going to explore that more in depth with the I-9 handbook in the next webinar on agents, but I have seen people be like, well, I talked to my HR and they said that if I get my own O1 with an agent at big company X, I'm not allowed to keep working there. I think that's employment discrimination and it's not allowed, but at the same time, it could be a really big hassle individually. But I think small companies don't care and startups would just be super happy if you could just start working and they didn't have to deal with sponsoring you. So I think it depends, but there's a lot of reasons why people might want to be able to do this used in the right context. Okay. Let's go to the actual criteria for extraordinary ability. So this is a very long regulation and it doesn't actually say in the laws pitch competitions. This is our interpretation of it that helps make it most clear for our clients, primarily working in the tech sector. So there are 8 criteria for the O1 visa for extraordinary ability for the O1A. There's a different category called the O1B, which is for artists, and it has a different set of about 5 criteria, and we use that a lot for UX UI designers. Sometimes if a founder has like a design background, it could go either way. They could qualify for an O1A or an O1B. And these extraordinary ability criteria are also very similar to the 10 criteria for an EB1A green card for extraordinary ability. So in a nutshell, have you won awards or prizes? Are you a member of organizations that are hard to get into because other experts in the field are admitting you based on their evaluation of your expertise in the field? Did people write about your work in the media or in technical journals, citations? Have you been the judge of stuff? Usually not the judge of students, but the judge of other professionals at the highest levels? Did you create something that's new or original in your field that's changed the way people do stuff? Are you an author? Have you written things, or have you been a thought leader in the circles that are relevant, or the media forms that are relevant in your professional field? Have you demonstrated your leadership in something leading or critical? And have you gotten a lot of money for whatever you've done? And so for all of these, it's super flexible, and a lot of it comes down to us as storytellers using the evidence that you can provide to us about the cool things you've done, and we'll figure out how to get it into these boxes, and we'll let you know if we need additional information to make it work. But there's a lot of ways to do it, and there's also very many ways that people mix and match these criteria depending on their background and their expertise and their field. So, we help a lot of founders, we help a lot of researchers, we help a lot of software engineers, we help a lot of influencers, and we help a lot of inventors. And the evidence you can cobble together about your accomplishments really depends on if you've been in school, if you've been in a big company, if you've been in small companies, if everything you've done is a trade secret, if your company has a strategy of filing patents on everything, or if you're a thought leader versus an engineer. There's going to be a lot more like froofy media stuff versus like hard science stuff. So it's like mix and match, and you only need 3. And, we kind of like having 4 or 5 that feel really solid so that we can make the strongest argument overall. But like, seriously, it's just 3. So founders often get like venture capital investment and articles written about them in like TechCrunch or Forbes or Business Insider. They've created some sort of disruptive technology. They have a founder role in some like fancy, flashy startup. They've joined some founder organizations, and their equity is worth a lot. Or we can argue that we can impute a valuation to their equity through their safe note or their convertible note and the cap. So that's like founders, right? And it's easier for that if you've already gotten some funding, but you don't have to. Sorry if there's background noise for me right now. For researchers, like if you've been in academia, if you've gotten a postdoc, it's probably a little bit different. Maybe your awards are grants that you've gotten. Maybe people writing about you is citations, and we can look at your Google Scholar for your impact factor. Maybe what you've created is actually what you discovered in your research. Maybe you were instrumental in leading some research group in your university, and that is your leadership role. Maybe you're a member of scientific communities and you're on some board, or you got some fellowship for your research. Maybe your judging is that you've been a peer reviewer of work. Maybe your advisor, maybe you do it for them. Maybe your name isn't even on it, but you did a bunch of paper reviews for your thesis advisor. You've probably written some articles. Maybe some are your first author, but not all. We can use the ones where you're not. And then well paid. Maybe your grants show that for a scientist in your field, you got more money than average for other scientists in the particular geographic area. So it's very, very flexible. Engineers at big companies, this is very common right now, especially for green cards. We're helping a lot of people on H-1B who want to upgrade from their like 2020 EB2 perm priority date from their big company to an EB1A self-petition, and to help their spouse get, an independent working status, and their whole family to get green cards. So that's going to be different, if you've been a product manager or a software engineer at a big FANG company. There's probably a lot of publicity about your work, but maybe none of it mentioned your name. You probably created a lot of stuff, but if you're at Apple, it's probably all secret. If you're at Amazon, maybe there's patents with your name on it. So it just depends. But the more users and the more your features are touted by, if you're in cybersecurity, it's really hard to show that you're a creator, because your company doesn't want to promote your, like, it's like, oh, no news is good news in cybersecurity, right? But in other fields where it's like enterprise software, your company is probably going to tout all the features that you created. So like what we can get just depends on what you were working on. Yeah, and then people do different things to try to increase their amount of evidence in each of these categories. Anything else on here, Linda, to mention?
I mean, I think it's just emphasizing that there's no one size fits all, right?
Yeah.
So like we do our job and we pull the information, and sometimes people don't even realize that something is really an accomplishment until we have that conversation, you know?
People are so humble.
They can be, yeah. So we know the right questions to ask, and we can do that assessment when we do an immigration consultation.
Yeah, that's amazing. That's so true. And we're actually going to be launching our next live cohort of Alcorn Academy, where it's an 8-week program to improve your credentials in each of these areas that I'm going to be leading with weekly classes. So we'll be getting more information to everybody on the webinar about that as well. Okay, so let's say that you've come to a conclusion on your O-1, like either you're going to do it now or later or not at all, but that's taken care of for now. How does a green card typically work in a big company, Linda?
So, you know, a lot of employers are apt to sponsor employees for a perm track green card. And that's where they're basically saying that, you know, they can't fill this job in the US labor market. And that's a Department of Labor structured labor market test. And from there, the case would shift hands and go to USCIS. So step 2 and 3 is adjudication by USCIS. And that's where, you know, step 2 in a perm context, it's just proving that you're qualified for the job and that the company can pay you the wage. And then the final step is adjustment of status if you're in the US. And that's basically you're going from temporary worker to green card holder. And that's also filed with USCIS.
Okay, great. Yeah, and so there's a lot here. What we're going to be talking about today is this step 2 I-140 petition, EB1 and EB2. We're actually just going to talk about a very narrow subset, the EB1A self-petition for extraordinary ability and the EB2 NIW self-petition for national interest. The beauty of this is that there's no perm, so you get to entirely skip that first step. And they have EB1 has the fastest priority dates. So that's the shortest time to get to step 3, the adjustment of status. But let's say you're a student and you need your very first priority date just to start waiting for your turn in line for an ultimate green card, because especially if you're from India or China, you might not be EB1 qualified yet, but if you have a master's degree or exceptional ability, we could start looking at an EB2 NIW for you even while you're still enrolled in school. And the sooner you get those dates, the less you're going to have to wait in your lifetime for a green card. So let's talk about how these weights work. Okay, so there's something called the visa bulletin, and there's something called a priority date. So in the green card process, the date you start can eventually convert into your priority date if your I-140 is approved. So if you're going through a perm-based process, the date your labor certification is filed becomes your priority date once your I-140 gets approved. And if you're starting with a non-perm self-petition, the date that EB1 or EB2 NIW I-140 is filed will be the date that becomes your priority date. And the reason your priority date is important is because when your priority date is current, then you're allowed to move on to step 3, which is filing your green card process. Most people are in the United States on a work visa, so they prefer to go through the I-485 route for adjustment of status because you get a work permit. Back in the day when everything was faster, sometimes people would prefer to file abroad, giving up the option for a work permit and doing their visa at a US embassy or consulate. So every month, the State Department calculates the number of green cards it's given out in each of the family-based and employment-based and lottery-based green card categories. And every day they publish a new update to something called the Visa Bulletin. And if you're physically in the United States, every month, U.S. Citizenship and Immigration Services, which has jurisdiction over your adjustment of status I-485, is going to publish their own new notice saying which of the two State Department charts they are going to be filing. So it's very convoluted. But in a nutshell, this is the new data for May of 2024. So let's say you're in the US and you have an old priority date, let's say 2017, and you were born in India, and you're trying to figure out if you should self-petition an EB-1A or an EB-2 NIW, and you know you want to do an adjustment of status because you live here, you're on H-1B renewals, your wife is on H-4 EAD. So you look at this chart this month. This is the May 2024 State Department final action chart. And this is what USCIS is following for the month of May. And you look at India, okay, if you file an EB-2 NIW, your 2017 priority date is still not current because they're only helping people who's got their priority date on or before April 15th, 2012. But if you want to file an EB-1A, you can do your adjustment of status now because anybody with a priority date before March 1st, 2021 would be current if you were born in India using your old 2017 priority date. If you were born in Germany and you're physically in the US right now and you're trying to figure out, oopsies, how long you're going to have to wait for your green card, well, if you can file an EB-1A now, great. You are already current with a brand new priority date for EB-1A adjustment of status. But if you want to take the easier path of like a master's degree in national interest, and you're just starting out with your very first priority date for the first time, and if we started your EB-2 NIW now and we filed it in 12 weeks, which would be, oh my God, July, it's going to be July. That's insane.
Yeah.
Okay, so you'll have a July 2024 priority date. And right now, they're helping people to file their I-485s if they have a priority date of January 15th, 2023 or earlier. So the people who are at the front of the line now started their wait a year and a half ago. We don't know how, if you're going to have to wait a year and a half, you might. But if a bunch of people got in line between January 2023 and July of 2024, you might have to wait longer than 18 months. And if less people got in line, you might have to wait less than 18 months. So it's a very loose predictor. Now, there's another chart in here in the Visa Bulletin, if you're looking at the Visa Bulletin, and it's called the dates for filing. And so this is specifically if you're going to get your immigrant visa abroad at a consulate. And most of our clients are in the US at this stage and they prefer not to do that, but there's slightly different dates. So just a little bit different, but that's why there's two charts. This one is if you're going to do a DS-260 immigrant visa interview abroad, but for most of our clients, it's this final action chart that governs their I-485. So getting a priority date is as soon as possible is really important because you can see that these wait times are kind of increasing globally. There used to not be an EB-2 backlog for the other countries category, but now there is. We're hoping in October that when the new government fiscal year starts and they can unleash a new crop of green cards, that this will jump forward. But, you know, in the past several years, India has jumped forward very little from these 2012 dates. It's been pretty stagnant. So that's the Visa Bulletin. So I don't know. My prediction, if you're born in India and China and you need your first green card and it's in EB-2, you might have to wait 10 to 15 years to get your turn in line. And that's why a bunch of people want to upgrade to EB-1A because that's the fastest category to get replenished every year. And a bunch of people can get it and move through that more quickly.
And I think the priority date retention thing is really important. So like if your company sponsors you for a perm and they did that 4 years ago, and now you're an entrepreneur and you've moved on to something different, you can do the EB-1A self-sponsored and you save that place in line. So you get that priority date, you can capture it from the prior filing, which is a really nice benefit.
Yeah, it's amazing. And the way that international students who are on F1, let's say you're about to graduate with your master's degree this May, we could do your EB2 NIW now to get you your first priority date, so that later you can jump ahead to EB1A, but you'll have an earlier priority date from 2024 instead of waiting until like a 2026 when you're ready for EB1, 2026 priority date. And the cool thing is that USCIS announced in December that if you're on F1, getting your OPT or your STEM OPT, it's okay if you have an approved I-140. They're still going to grant your OPT. So that was a really cool clarification, that sort of shows that they understand that most international students want green cards and that they're okay with it. So it's very exciting. Okay, so for the EB1A, just a few notes on these two types of green cards, and then we're going to go to questions. For the EB1A, it's very similar to the O-1A for extraordinary ability. Instead of 8 categories, there's 10 categories because there's 2 more for artists that got lumped in. This is definitely the fastest green card. Premium processing is only 15 days. Adjustment of status is anywhere from 6 to 18 months, but your priority date is most likely to be current in this category. So overall, the green card, might take, you might be able to get a green card in as little as like 9 to 12 months if you have a current priority date. If you're from India and you're just getting your first priority date and you're going for EB1, I've heard that there could be like a 4-year wait right now if you're just getting started in EB1. It's so hard to verify if those numbers are true. And even if somebody thinks they're accurate now, so much of this is subject to change in the future. But this is absolutely the fastest way. And this is where we're showing those categories. And, because you have reached 3 of the 10 in your narrow subfield in the US or another country, and because you have sustained national acclaim as shown through that evidence and letters of recommendation, that you're determined to be at the very top of your subfield and that you're a person of extraordinary ability. And for the EB2 NIW, it's a very, very different construct. It's like, okay, you either have a master's degree or 5 years of experience or exceptional ability, which is way easier than an O-1. You could be a college dropout and have some certifications and be in some just like IEEE basic membership, not even senior fellow, and maybe a couple more things and qualify for exceptional ability. But the real thing here is, how are you going to help America in the future? Why are you in the national interest? And what is your proposed endeavor for what you're going to be doing once you get this green card? And why shouldn't we replace you with an American who could do it instead? So this really optimizes for potential. For the extraordinary ability stuff, it's like, what did you do in the past? And why are you already extraordinary? For EB2 and IW, it's just doesn't matter if you're extraordinary. It's just like, okay, what are you going to do for us in the future? And we do a lot of these with business plans for aspiring founders. I would want any business plan to be in good faith, even knowing that you might have to wait like a decade for your spot in line to become current if you're a student. Premium processing a little different here. It's 45 days instead of 15 days. And just the main thing to note is that the wait time for your priority date is a little bit longer. But this is the best way for a student or somebody who's new to the US to get their very first priority date if they're not current for EB1A yet. Okay, all right. So options, and then we're going to go to questions. And this actually relates to one of the questions we've gotten. Okay, so first of all, lots of things to consider. Your time, your energy, and your commitment to giving us your evidence is actually a pretty major factor. We can't, unfortunately, just snap our fingers and do this whole thing for you without you doing anything. You have to be a part of the process and get us your information promptly so that we have something to work with. You're going to be paying legal fees. We charge flat fees. For an O-1 with a visa, we charge $12,250. For an EB-1A or an EB-2NIW self-petition, we charge $11,750. That's for everything to file in 12 weeks. If you want to file in 6 weeks, we can expedite it for $5,000 if we have capacity. And then we include 4 white glove letters of recommendation, where instead of giving you our templates and editing your drafts of the letters, we literally have one of our team members write all of your 4 letters for you from start to finish, so you don't have to lift a finger. And if you want to do 12-week processing plus white glove service, it's $500 per letter. And typically we help with 4 to 6 letters. So we're happy to give all that information to you individually in a consultation after we assess, which possibility is right for you. But certainly planning your financial budget is important. There may be additional things that we need, translations, evaluations, various things that could tie into it. But in addition to that, you can't just like swipe your credit card and think it's done. You have to be an active part of the process. And a lot of people's imposter syndrome kicks in, as well as this whole thing can be triggering. So having a good support system to help you get through really helps us help you. And now Dara asked if we have ways to help people build their profiles. So yeah, I mean, over the years, the question is, do you need the profile built already to take on the case and go ahead and file? So I used to need the profile built all the way, and I felt really bad because there's so many brilliant people that I wish I could help, and I've been trying to figure out ways to help everybody build their profile. So we do have an online class, which is available year-round, anytime. It's 15 self-paced video modules. One of the main things people really love about this is that I did a deep dive on the regulations and the requests for evidence that were very common, so that you could get an idea of which types of evidence might qualify so that you can brainstorm it in your field. But the other cool thing that we're about to launch, and you can see it in the webinar chat, we have an interest list up for a new variation on this, which is Alcorn Academy Live. And this is going to be an 8-week session that I'm going to run, where I'm available for Ask Me Anything to help you figure out your field of ability, if your evidence is good enough. So this is going to be a cohort-based program. We just completed the first invite-only beta cohort, and it was really, really successful. People really loved it. So we're going to be launching the next one for the months of May and June with once-a-week sessions with me, probably on Thursday morning Pacific time. So I'm really, really excited about that. But this online class is already available. Go to the chat window and click on the interest list for Alcorn Academy Live if you want to build that cohort. And thank you for that question. And once you might have enough evidence, but you're not sure if it's enough, but you want to double check before you hire a lawyer and get a sense of if there's anything else you can do to round out your petition, that's where we would invite you to do our program called Legal Launch, which is our evidence assessment program. And it's a 4-week program. It's $2,500. At the end, we either tell you, you're more than sufficient, let's start your case today, or here's your personalized checklist. Please go take six months to complete the rest of your stuff. Come back to us for a complimentary follow-up evaluation. And if we can accept your case, we'll be happy to credit the $2,500 to your O-1, your EB-1A, or your EB-2NIW filing fee in the next 6 months. So that's very effective for people as well. And if you want to reach out to us for a consultation, you're going to get our questionnaire. It's going to have these check boxes, and this is what helps us get to know a little bit about you and get that consultation scheduled. Okay, and with that, we have a few more minutes for questions. So let's try to get through them. Okay, so here's the first question, Linda. O-1A to EB-1A, they're filing the I-140 in their first 90 days. Should they be cautious about it, or can they send it without worry? They first entered the US on the O-1A on April 1st, and they're a bit confused on the intent situation with the O-1A. Would you like to speak to this, or would you like me to?
Yeah, I mean, I can speak to this because, the I-140 is treated a bit differently than the 45. So the I-140 is the immigrant worker petition. And if you're here on an O-1A, you typically have what's called quasi dual intent. So there is more flexibility. And I think, after your admission in April, your plan is to wait. If you're planning to wait 90 days, you certainly can do that. But I don't necessarily think you have to, because again, I think there's flexibility with the O-1. Some other categories don't have as much flexibility. If you came in as a B1, I would say you need to wait 90 days.
Yeah. Yeah, great. Wonderful. Thank you so much. It's different for different visa types, for sure. And in the Trump administration, it was different if it was your first visa versus your second entry on that visa. And there's also a 60-day thing. But yeah, I agree. This person should be fine. And we've even had people with approved EB1As have to consular process an O-1 extension, and it's been totally fine. So yeah, it's good. So somebody is the CEO and founder of a company on OPT. They were interested in having their company be the petitioner for their O-1 visa. And they're wondering if that's okay or if they would need to restructure. This is totally fine. If you don't want an agent, but you already own a company and you want that company to be your petitioner so that you can be the CEO, we can do that. We could have a co-founder with signatory authority sign for you. Maybe there's like a board member who's a secretary or something that has signatory authority. Maybe you have an HR person in your team that routinely signs these things. But I think there's a lot of ways to do it. Would you agree? Yeah.
Definitely.
Okay, great. For EB1, comparable evidence is the letter of support from the petitioner enough to establish the criteria is not available. I don't understand this question. Establish the criteria is not.
So maybe if like you judged on a panel and you don't have evidence, they're saying, can that letter of recommendation maybe fill that, provide that evidence, which I don't think, yeah. That's how I'm interpreting it.
Yeah. If we're not answering the right question, reach out to us for a consultation. Letters of support from petitioners can definitely serve as evidence, but I think of them more as the glue to tell the story in a profound way and tease out connections and show your responsibility for things. But we always want to have documentary evidence where we can, and it could be as simple as a calendar invite or an old email that you've printed to PDF or a photograph at some event. So there's lots of ways to do it depending on the specific criterion that you're talking about. And it looks like our team is making sure that we can get you access to the interest form for Alcorn Academy, and we'll also be sure to send that to everybody in the follow-up email along with the recording link, and we'd love to have you. Okay, and this looks like it's going to be our last question. I'm curious about the charges, the filing fees. We charge flat fees, which are not the cheapest, but they're not the most expensive. We try to make it as clear and simple as possible. So if you need a specific quote for your situation, you are more than welcome to get in touch with us for a consultation. But we need to maintain our flat fees as these are very, very labor intensive filings. We do our best. We don't charge by the criteria. We have people with over 20 years of experience working on helping you put your best foot forward. And part of the reason, for the 12-week time to filing is we want to make sure you have enough time to give us absolutely everything you can. And we need our team to be able to carve out days of unstructured thinking, focused time to solely work on you and make sure that we are putting together absolutely the best argument possible for you. So we're not necessarily the best law firm for everybody, but we try to make it clear of who we are and what we stand for so that if we're right for you, you can access us. And For the I-485, would you also wait 90 days on an O-1 visa if you get your I-140 approval? I don't know, Linda.
Yeah, I mean, I think we'd have to look at the individual circumstances. So
Yeah.
it's not an easy yes or no answer.
Yeah.
It's a maybe.
And if you're DIYing this, then you can pay us for a consultation. We are on a case-by-case basis able to offer complimentary consultations, but if you know you need legal advice, we can do that for a paid consultation. Alrighty, and so, do encourage you to reach out. You can get my book. It's available on Kindle and Audible. Ask Sophie, the Founder's Guide to Visas and Green Cards. It's a choose your own adventure travel through the world of visas and green cards for yourself and your growing team. So definitely encourage you to get a copy of that. And most of all, we would love to help you. So please reach out to us. You can scan the QR code. You can go to our website and complete the contact form. And whatever you need help with, you're just welcome to put a note in about that. And our team will be glad to give those resources to you. Well, thank you, Linda, so much. This was a lovely webinar, and I very much appreciate you doing this with me here today. And thank you, everybody, for attending.
Great. Thanks so much, everyone. Have a great day. Take care.
Thank you. Bye.